I welcome you all to another guest lecture of the Global South Network guest lecture series. The format of today's guest lecture is slightly different from previous guest lectures. Today is more like a dialogue among the judges of Supreme Courts of different countries, for which I'm very, very grateful. Special thanks to all of the judges of Supreme Courts of different countries, including but not limited to Supreme Court of Israel, Supreme Court of Ethiopia, Supreme Court of Kenya, the Constitutional Court of Turkey, the Constitutional Court of Kyrgyz Republic, the Supreme Court of Ukraine, Supreme Court of Greece, Supreme Court of Mauritius, Supreme Court of Malaysia. Before I go further, it's important to explain the aim and objectives of the Global South Network. What is the scope of the Global South Network? The Global South Network is the first ever international interdisciplinary network that is by and of the Global South, serving both Global North and Global South, and that is aimed at empowering people from or focusing on the Global South. This guest lecture series is one of the initiatives of the Global South Network. The network has two major approaches, two major focuses. One is the regional focus, and the other is the disciplinary focus. Within the disciplinary groups, we have politics, international relations, law, criminology, health, well-being, and caring. When it comes to the regional approach, we have different groups, including but not limited to Latin America, Middle East, East Asia, Southeast Asia, South Asia. All of these groups together, their main aim is to bridge social, political, economic, ideological gap between of different organs of the state and people of the Global South and the Global North. And in fact, this is the main idea behind the Global South Network, that we do not look at the Global South as a concept, as an academic concept, which is discussed by political scientists, legal scholars, economists in different ways. Economists describe it in terms of middle income, low income countries, as political scientists define that as authoritarian states, hybrid states. For us, the Global South Network, it is an idea. It is a means to achieve other ends. Idea that bridge as I said, bridge different gaps between different countries, gaps such as the political gaps, social gaps, religious gaps. And it's very important given the volatile international environment we have in the Middle East, in the East Asia, in South Asia. It's very important to have people-to-people contacts. When it comes to Global South Network, it shares an interest with organizations like Association of Asian Constitutional Courts, the European Constitutional Courts Association, Association of Commonwealth Judges and Magistrates, interest in knowledge exchange and sharing good practices between judges. But we add to that interest, to that focus, the knowledge exchange and sharing good practices between civil society actors outside the judiciary, policymakers, and diplomats. Since its establishment in March 23 as a founder and convener, Global South Network, I've been working on expanding the network and moving it beyond from academic activities to involving actors outside academia. And this included the establishment of advisory committee, introduction of different initiatives such as International Interdisciplinary PhD in Progress seminar series, which bring together PhDs, actors outside academia, lawyers community, and practitioners from different parts of the world every week. Since March 2023, we have organized around 110 activities, published 2 editorial collections, introduced 3 initiatives, including but not limited to the mentoring and coaching schemes that encourage PhD candidates from different parts of the world to apply for the PhD scholarships, and also encourage early career researchers to apply for different research projects. And that resulted in 2-3 success stories. One success story was about the PhD scholarships, and 2 stories were about the early career fellowships. Having this said, I must say that today's guest lecture is unique in sense, and I think that's one of the major queries which I receive from different parts of the world. What's the connection between global North people and the global South activities? And I think the acceptance of this invitation, arrival of our today's guest speaker, Honourable Lord Reed, President of the United Kingdom Supreme Court, fits very well within the scope of the Global South Network, within the idea of the Global South Network, that is the bridging the gaps between 2 regions. And the topic is self-explanatory: North-South cooperation, judicial cooperation between the Global South and Global Now. On behalf of the Global South Network members, lawyers, judges, academics, journalists, I warmly welcome you to the Global South Network Guest Lecture Series. It's an honor to have you during this lecture series. And I'm really looking forward to many more collaborations in the future, bilateral and multilateral collaborations. Having this said, I invite our Honourable Pro-Vice Chancellor, Head of the College of Social Science, Arts and Humanities, Professor T. S. Sanders, to come to the podium and deliver welcoming remarks on the behalf of the Honourable Vice Chancellor, University of Leicester, Professor Nishan Panaraja.
Good afternoon, everybody, and welcome to people in the room here in Leicester, colleagues and students, as well as online, internationally, across the globe. What a fantastic event for a Monday afternoon here in the UK. My name is Tila Sanders. I'm the Pro-Vice Chancellor and Head of College of the Social Sciences and Arts and Humanities, which the School of Law sits in, and certainly takes pride of place in terms of its stature, the numbers of students and staff delivering absolutely fantastic teaching and research. A huge welcome and thank you for being here. I'm here on behalf of the Vice Chancellor, who at this point in time is in India, doing his definite thing for the Global South in terms of demonstrating our commitment to continued relationships. He is there with other colleagues from the university to launch our Centre for Digital Health and Precision Medicine with our partner Apollo in India. He apologises for not being here, but he certainly supports the event and the Global South Network. I just want to say a few words about Dr. Reayat in terms of his absolute impact on the university in his short few years of being here. You've only been here for a few years, literally 2 years, 3 years, you were in your 3rd year possibly, and last year received the University's Citizens Award, the Citizens Award, for your absolute dedication to the Global South Network and bringing people together here. I think today, and the Global South Network really does demonstrate the values of the university in terms of inclusion, impactfulness, and innovation. This series, this event today, is really about that. So thank you for your continued support and dedication to the Global South, and for just being an excellent role model to students and to colleagues alike. The series has been fantastic. Lord Reed, thank you so much, and distinguished guests online. This really should be a fantastic event. I'm going to hand over Professor Carlo Panara, our Head of the School of Law, to do a more personal introduction.
Thank you, Tila. So, first of all, I would like to thank the Right Honourable President of the UK Supreme Court, Lord Reed, for being our guest today, and a welcome to the law school, welcome obviously to the University of Leicester. We're very proud and honoured to have you here today. Let me say that it is very important for us to have you here because obviously you are an inspiring figure to lawyers, especially young lawyers who study law in the law school. And of course, you are a role model for students, for staff, but also for members of the local law society. So we have the honor of having today here the president of the Leicestershire Law Society. And obviously that shows the connections between the school and the local legal professions. So it is important that these opportunities to bring together members of the judiciary and obviously members of the law school, students, staff are created, and I'm very grateful to Nauman, so I echo what Professor Sanders just said. It's very important that these opportunities are created to create role models and opportunities, but also to remove barriers. Sometimes there is the misconception that legal professions, barrister profession, but also in particular the judiciary are out of reach for many who undertake the study of law, which is very demanding, difficult. But I believe that events like this can actually contribute to remove these barriers and to remove these misconceptions. So I would just like to conclude by saying that I'm sure that you all will enjoy this guest lecture, will be inspiring. I hope that you will enjoy obviously lecturing and meeting obviously all staff and students today. I would like to thank again Nauman for creating this opportunity, but ultimately I would like to thank you again, and I'm happy now to leave the stage to the Right Honourable President of the UK Supreme Court, Lord Reed. Thank you so much.
Well, it's a great pleasure for me to give this lecture on judicial cooperation between the UK and the Global South, and to be able to engage in this way with colleagues from around the world. I'm grateful to the network and to the University of Leicester for giving me this opportunity, and to Dr Reayat for organising and moderating the event. I'm also grateful to the many distinguished colleagues who have agreed to provide online responses. Judicial cooperation and dialogue between the UK and the Global South are not new, but they've become increasingly important in recent times. As the President of the Supreme Court, I have frequent contact with judges in the Global South and elsewhere, sometimes in order to discuss problems of common interest, and sometimes in order to provide advice or help to organise training. All of my colleagues also have contact with judges in other jurisdictions. Through these contacts, we and our counterparts in other jurisdictions are able to exchange good practices and to learn from each other's experiences and jurisprudence. Our exchanges offer new perspectives and opportunities for reflection. Our own solutions do not always appear as obvious as before. This forms part of a wider landscape of judicial cooperation between the UK judiciary as a whole and the Global South, which encompasses a range of activities and initiatives designed to foster dialogue, to build relationships, to enhance mutual learning, and to provide opportunities for judicial capacity building. This development has begun to be reflected in a growing recognition of the importance of international judicial engagements on the part of the UK government. The Foreign, Commonwealth and Development Office, for example, has increasingly supported the Supreme Court's international work, resulting in a closer relationship between the Court and the Department's judicial diplomacy team. And it's resulted in concrete support during some of our visits overseas, such as I received during a visit to Brazil last year, and also during some visits to the UK by judges from other jurisdictions. Recently, for example, the Department provided support for visits to our court by delegations from Indonesia and Montenegro. This engagement between the UK judiciary and judges of the Global South has many different dimensions. One long-standing aspect is the need for international judicial cooperation to address disputes involving multiple jurisdictions, from the conflict of laws to the implementation of international law, from the enforcement of foreign judgments to the recognition of our own judgments in other jurisdictions. The interaction of legal systems has long presented judges with challenges. These have grown in modern times. Populations have increasingly moved beyond their borders to work and to form families, or to avoid hardship and danger. The social and economic impact of globalization, climate change, and armed conflict have made us increasingly conscious of our mutual dependence. Developments in communications and transportation have created truly global trade, where funds can be transferred from one jurisdiction to another at the click of a computer mouse, and where contracts are concluded and wrongs are committed across borders every minute using online platforms. All these factors, and many others, have generated an increase in the number of legal relationships which have foreign elements, and have created legal challenges across our jurisdictions that require similar or at least coherent judicial responses. In this context, the UK judiciary and Supreme Court in particular have made a serious effort to engage with other jurisdictions through judicial visits, bilateral activity, and as part of multilateral organisations. This can involve welcoming visiting judges and providing programmes of activity, engaging in roundtables on legal or constitutional subjects, taking part in conferences on matters of mutual interest, and providing training in judicial skills. Our principal aim is to strengthen the rule of law globally by helping to support a robust and fair justice system and the independence of the judiciary, both in individual countries who seek our support and through international networks. In assessing the significance of these developments, I'd like to begin by saying something about the historical and cultural background. I'll then turn to a particular mechanism of engagement which has its roots in history but remains active in the present day, namely the Privy Council, a court which is based in the UK and staffed mainly by UK judges, but sits as the highest court of a number of jurisdictions in the Global South. I particularly want to draw attention both to the interchange which that institution encourages between judges and lawyers in the UK and in the Global South, and to the experience and insight which it gives British judges in relation to the legal problems of other countries at a different stage of economic development. I'll then turn to consider wider judicial cooperation and dialogue in relation to matters of substantive law. Finally, I'll consider judicial cooperation and dialogue in relation to other aspects of the courts, such as the maintenance of public confidence in the judiciary and the protection of the independence of the judiciary. My overarching theme is the role of international judicial cooperation in maintaining the rule of law and democracy around the world. Beginning then with the historical and cultural background, in the relatively recent past, we've seen a major development in international judicial relations. compared with the situation when I first qualified as a lawyer over 40 years ago. But we're following in a long tradition which in Europe can be traced back to the ancient world. The relationship between the UK Supreme Court and the Global South today is influenced by important historical factors, as well as by contemporary issues and concerns. Indeed, the links between the historical and the contemporary are indissoluble. It's because of history that the UK shares the English language with many countries in the Global South. A shared language and, in consequence, a culture which in some measure is also shared. Indeed, because we in the UK now include many people whose families have come here from the Global South, our language today is influenced by the language of the Global South, particularly the Caribbean and the Indian subcontinent. Our culture is less traditional than people in other countries might imagine. It's also because of history that the UK has a shared legal tradition with many countries in the Global South. The common law, originating in England, is now, for reasons of history, the basis of many countries' legal systems. They include many countries in the Global South, such as India, Pakistan and Bangladesh, Botswana, Ghana, Kenya, Tanzania, Uganda, Malawi, Nigeria and South Africa, Malaysia and Singapore, and many other countries. Other countries in the Global South have legal systems which are based on a combination of common law and civil law sources, as in Mauritius and the Philippines. So there are a great many courts in the Global South with which our court shares a legal tradition and a method of legal reasoning, to some extent at least. In many cases, we also share with them a constitutional tradition based on a representative democracy on the Westminster model. Those of us who sit on the UK Supreme Court are conscious of this shared tradition, and we encourage the citation of judgments from other common law jurisdictions in argument before us. Judgments from some of the countries that I've mentioned, such as India, Singapore, and South Africa, are regularly cited before us. We're also aware that many courts in the Global South consider our court's judgments as a possible source of ideas and possible guidance. This is due in part to the relationships that our court has developed with the judiciary in those jurisdictions. For example, in the last year or two, we have welcomed judges to our court from such common law or mixed jurisdictions as the Bahamas, Mauritius, India, Malaysia, Brunei, Ghana, Kenya, and Nigeria. It's unsurprising if judges from those jurisdictions, which incorporate at least partly the common law method into their legal systems, may refer to our jurisprudence in their judgments. But the links between the UK and the Global South are not only historical, and they are not limited to countries with which the UK has had a historical relationship. There are strong family ties between our citizens and people living in the Global South, especially in the Indian subcontinent and the Caribbean, but increasingly also in other countries, particularly in Africa, the Middle East, and the Far East, as populations have moved across national borders. There are also strong commercial connections reflected in legal ties, as the common law is used today to govern contracts in countries where English law was never introduced by a colonial power. There are ties based on shared economic or defensive interests, often reflected in shared membership of international organizations. And there are relationships based on a mutual recognition that our different countries have a common interest in stability and in the international rule of law. Let me turn next to a particular mechanism of engagement between the UK and the Global South, which has its roots in history, but remains active in the present day, namely the Privy Council, the judges of which are normally also the judges of the UK Supreme Court. The jurisdiction of the Privy Council originated at the Norman Conquest, but its judicial work greatly expanded in the 19th century, when it became the highest court of appeal for the British Empire. Its scope has greatly diminished since then, as the colonial era came to an end, and most of the countries in the Commonwealth established their own highest courts. However, some Commonwealth countries have chosen to keep the Privy Council as their apex court, even though they have become independent. Currently, the Privy Council is the highest court of appeal for 11 independent Commonwealth countries and for 18 overseas territories, crown dependencies and sovereign base areas. All of the independent countries and almost all of the overseas territories are in the global south. Many of them are in the Caribbean, some are in the Indian Ocean, some are in the Pacific Ocean, others are in the South Atlantic or the Mediterranean or around the British Isles. In other words, they're all around the world. They keep us busier than you might think. Last year, we delivered almost exactly the same number of Privy Council judgments as Supreme Court judgments. Deciding these appeals requires the judges of the Privy Council to engage very closely with legal issues arising in countries belonging to the Global South. We become aware of the sorts of issues which commonly arise in the societies we serve. Many of the issues are similar to those arising in the UK, such as cases involving tensions between commercial development and the protection of the environment, for example, in relation to tourism in the Caribbean or commercial fisheries in the Pacific, or cases concerned with undocumented immigration, for example, from Venezuela into Trinidad and Tobago. Some issues are of a broadly familiar kind, but they arise in a different social context. For example, questions concerning the legal recognition of same-sex relationships. Other issues are of a less familiar kind. For example, there's quite a high number of cases in the Privy Council concerned with electoral laws and the redrawing of electoral boundaries. In order to perform its role, the Privy Council needs to be accessible to the people that it serves, and it also has to engage with lawyers and judges in those jurisdictions. Since I became the President of the Supreme Court, we've tried to improve the accessibility and engagement of the Privy Council in a number of ways. First, we have for some years offered hearings online, so that it's unnecessary for the parties and their lawyers to come to London. The lawyers can take part in hearings from their offices in their own countries, and their clients and interested members of the public can watch the hearings online as they're all live streamed. Secondly, we've established meetings of court users in which Privy Council judges take part, and an annual newsletter which is sent to users. Thirdly, and in my opinion most importantly, the UK government last year accepted my proposal that judges from the jurisdictions that we serve should be eligible to be appointed as members of the Privy Council so that they can sit with us on appeals. I made this proposal because it was clear to me that having the benefit of judges with direct experience of local conditions could only enhance the quality of the Privy Council's decision-making. The first such judge to be appointed was Dame Janice Pereira, formerly Chief Justice of the Eastern Caribbean Supreme Court and President of its Court of Appeal, who sat with us in December. She will be sitting with us again during this coming year, and I'm hoping that another judge will be appointed in the course of this year. More, I hope, will follow over time. Fourthly, my colleagues and I have accepted invitations to participate in events involving judges from the Privy Council jurisdictions. For example, in my case, by giving an online lecture last year at the University of the West Indies in Jamaica, which was followed by a panel discussion involving Jamaican lawyers and academics. And by taking part last year in a conference of Caribbean judges on combating financial crime. That conference provided me with the opportunity to meet or renew my acquaintance with many judges of courts in the Caribbean from which the Privy Council hears appeals, in addition to courts from other countries in the region, such as Guyana and Belize. The conference demonstrated the value of bringing together the judiciary of different countries in a region who are experiencing similar social problems and have similar legal traditions in order to share legal knowledge and experience and discuss best practice. Fifthly, we continue to accept invitations for the Privy Council to sit in the jurisdictions that it serves. These invitations are always most welcome. In my time on the court, we have sat in Mauritius, the Bahamas, and the Cayman Islands. So the Privy Council is a forum in which UK judges engage in a particularly sustained and focused way with lawyers and judges and legal systems from the Global South. But of course, our contacts and relationships with the Global South extend far beyond the Privy Council jurisdictions. So let me turn to wider judicial cooperation and dialogue, first in relation to matters of substantive law. The practical value of international legal discussions is evident when we are considering common legal problems or problems which require international solutions. To give just one illustration, many countries in the Global South are important financial centres providing sophisticated banking, corporate and legal services to international clients. Such jurisdictions are inevitably liable to attract individuals and organisations wanting to commit financial crime or to conceal the proceeds of criminal activities. Combating money laundering is important if we are to combat the drug cartels, people smugglers, and other criminal gangs who want to launder their profits or hide their gains behind an opaque screen of offshore trusts and companies. But it requires international cooperation, as the drug syndicates and people traffickers take advantage of the open borders, free markets, and technological advances of a modern world. A related problem in many countries is the use of illegally obtained funds to achieve political influence. We all know countries where organised criminal syndicates have become powerful and entrenched, penetrating political parties and undermining government and law enforcement. Corruption produces incalculable damage to governments and societies and weakens democracy and the rule of law. Like financial crime and drug and people trafficking, corruption is a phenomenon found in all countries, big and small, rich and poor. But it is in the Global South that its effects are most devastating, as it diverts funds that are needed for development and discourages inward investment. In light of this, and given the ease and speed with which the proceeds of crime can be transferred from one jurisdiction to another, courts around the world, both from the Global North and Global South, need to work together to enhance international cooperation in this field. Another illustration of the importance of judicial dialogue and cooperation is extradition, which involves states working together to transfer individuals accused or convicted of crimes from one jurisdiction to another for trial or punishment. This can be hindered by the fact that different countries have different legal traditions, and their courts may hesitate to extradite citizens for trial under another system of law. Judicial dialogue can bridge the gap by fostering mutual understanding of legal procedures, evidentiary standards, and decision-making processes. Some countries may also require technical assistance and capacity building to strengthen their legal frameworks and judicial institutions for handling extradition requests. This may include improving the rule of law, addressing corruption, and ensuring compliance with international standards. Frequent contact with judges in other jurisdictions allows us to understand better how we can assist one another to improve the efficiency of extradition in a manner that complies with robust, substantive and procedural safeguards, and can help us to address perceptions of bias or double standards in extradition processes. But the value of judicial dialogue and cooperation is not confined to addressing shared problems. In the field of commercial law, for example, where cross-border transactions are very common and are assisted by standard forms of documents, a degree of convergence of law and practice across jurisdictions is economically efficient since it reduces transaction costs. This tends to make jurisdictions sharing a common approach more attractive to each other as destinations for investment or as sources of collaboration. This is something of obvious importance to the UK as a common law country sharing a legal heritage with about a third of the world's population, and also because the common law governs about 80% of global trade. As we've said in our judgments, although it's inevitable that inconsistencies in the common law will develop between different jurisdictions, it seems to us highly desirable for those jurisdictions to learn from each other and at least to lean in favour of harmonising the development of a common law around the world. One important forum for judicial dialogue is the J20, the meeting of the most senior judges of the G20 countries, including Argentina, Brazil, China, India, Mexico, South Africa and Turkey, as well as the UK and some other countries in Western Europe, North America and Australia, together with the European Union and the African Union. Last year I attended the most recent meeting, which took place in Brazil and focused on the role of the judiciary in relation to social inclusion and climate change, and on the challenges to the courts posed by artificial intelligence. I also take part each year in the Global Constitutionalism seminar held at Yale University. It's attended by senior judges from a number of countries from the global south, including Argentina, Brazil, Ecuador, Colombia, and Pakistan, as well as judges from Western Europe, North America, and Australasia. This group engages in stimulating and constructive discussion of current issues of importance in constitutional law, and has been a way of building international understanding of the challenges faced by judges in different parts of the world, and also of providing support to judges who face challenging circumstances. I've also taken a particular interest in helping to develop judicial capacity in countries in southeastern Europe. For that purpose, I've made a number of visits to Bosnia-Herzegovina and to Croatia, and I'm hoping to spend time later this year with judicial colleagues in Montenegro. A recent development is the use of the internet to have online meetings with foreign judges. We've held meetings in this way with the Supreme Court of Japan and the High Court of Australia, and following my meeting last year with Chief Justice Zondo of South Africa at the J20 meeting, we've recently invited his successor, Chief Justice Meyer, to hold a virtual bilateral meeting with us. The importance of judicial dialogue is also understood by many of our visitors from the global south. For example, in 2023, I welcomed the ambassador of Vietnam, who noted that trade and commercial relations between the UK and Vietnam have prospered over recent years. He spoke of Vietnam's ambitions of developing a regional financial and business centre that is attractive to both global and UK investors. I explained that commercial law may be an area where the UK can share experience, possibly through organised judicial exchanges. His visit is to be followed up by a visit this year by the Chief Justice of Vietnam. Similarly, our court welcomed a visit from the Vice Minister of Finance of Kazakhstan, who spoke of the success of the Astana International Financial Centre and International Arbitration Centre, a commercial court in that country which uses a legal code with much in common with English common law. The Minister discussed with us how the judiciary can support wider commercial policy reform across the country. Some other judicial delegations have wanted to learn about the way we manage hearings and appeals, particularly in commercial cases, including our methods of case management and our use of oral hearings. This has been a theme, for example, of our meetings with delegations from Indonesia. Another illustration is our discussions about a wide range of legal issues with judges from Ukraine. My involvement in these started in 2022, when Ukraine was granted observer status at the annual meeting of the network of presidents of Supreme Courts of the EU, of which the UK is an associate member. That gave me the opportunity to engage in discussions with the president of the Ukrainian Supreme Court. He later invited me to speak via an online link at a conference of Ukrainian judges in 2023. Later that year, President and I took part in a roundtable discussion in London on the topic of Ukrainian courts and the justice system during a war, which was attended by a delegation of senior judges and politicians from Ukraine. In addition to discussions focused specifically on the war, topics included capacity building of the Ukrainian judiciary, such as training programs for judges, and the implementation of digital technology in the work of the courts. It also included a discussion of institutional arrangements for the selection and appointment of judges. Last year, our court hosted a delegation from Ukraine, which included Supreme Court judges, the Minister of Justice, and the head of the Committee on Legal Policy. They were particularly interested in gaining an understanding of the UK court's practices in considering commercial disputes and how to adjudicate such cases fairly and independently. More international visits and events are, of course, in the pipeline. For example, I've been invited to give the keynote address in May this year at the Ibero-American Judicial Summit in the Dominican Republic, following a visit of the Chief Justice of the Dominican Republic to our court last year. That event brings together judges from the Spanish and Portuguese-speaking countries of Central and South America, Africa, and Europe. Other regular events for us include the Commonwealth Law Conference being held this year in Malta, and the Commonwealth Magistrates and Judges Association Conference being held in Gambia. We receive incoming visits almost every week from judges and justice ministers from around the world. For example, during November and December, we welcomed delegations from Kosovo, Montenegro, Israel, Egypt, Nigeria, Kazakhstan, South Korea, and Canada. In the past week, we have received delegations from Montenegro and Sweden. In my experience, the majority of our judicial visitors are interested in aspects of our work that do not relate to the law in a strict sense or to our judgments. They want to discuss the UK Supreme Court's approach to ensuring its independence, how it engages with the government and Parliament, its approach to communications, including with the press and on social media, and its work on transparency and on improving its accessibility and the public's understanding of its role. They're also interested in our use of technology in relation to these matters. For example, our approach to transparency and public engagement was a subject of interest to a recent visiting delegation of judges from the Constitutional Court of Bosnia-Herzegovina, who wanted to find ways to build greater trust in the courts across their community, and also to visiting judges from the Dominican Republic. We demonstrate to them how we live stream our hearings and the delivery of our judgments when we give a short explanation of a court's decision in ordinary language. We explain how we are advised about the language that we use and about other aspects of our communications with the public by a professional communications team who form part of the court's staff and include former journalists. They also liaise with the media to ensure that our judgments are accurately reported. Many judges in the Global South have informed me that they would like to see a similar approach adopted in their own jurisdictions to improve the transparency and accessibility of their courts. Other visitors to the court from the Global South, such as the Attorney General of Bhutan, who visited us in 2023, have taken a particular interest in the court's education and outreach activities, which are intended to improve the public's understanding of the court's role. Another popular topic of discussion is how the court maintains its independence, how it responds to political and media pressure, and how it engages with the world of politics. We have some experience of problems in this area, just as judges do in other countries, and discussions on this topic can assist in learning from each other's experiences and developing best practices. Many jurisdictions in the Global South are also, like the UK, interested in increasing diversity among the judiciary. They're interested in our judicial diversity and inclusion strategy and the steps that we've taken to pursue it. The final topic I'll mention is the application of technology in our court. Visiting judges often take an interest in this. For example, when the Attorney General of Bhutan visited us, he was particularly interested in the Supreme Court's live streaming and digital recordings of previous hearings, which I mentioned earlier, and also our online educational programs, including programs for schools and universities. Many of our discussions nowadays also concern the use of artificial intelligence, which we are beginning to introduce in a cautious way. To conclude, it's evident from the UK's cooperation and dialogue with the Global South that a commitment to justice and the rule of law is a shared priority of judges around the world. As judges, it is our vocation to give people a reason to believe that justice is possible. We have a duty to do our best to make justice happen every day, and to try to make the world more just for all of our citizens. Justice and the rule of law are also goals which many people outside the law understand are important to economic prosperity and to personal security. At the same time, judicial independence and the rule of law are under pressure in much of the world. In this context, by addressing shared challenges and promoting equitable partnerships, judicial contact can enhance understanding and cooperation between the global north and the global south. That can only contribute to global justice and security. Thank you very much for listening to me.
Thank you very much. Thank you, Honourable Lord Reed, President of the UK Supreme Court, for delivering a very insightful guest talk on judicial cooperation between the United Kingdom and the Global South.